Okay, good afternoon. Good afternoon to everyone. Okay. So unfortunately, today is going to be a little bit, I'll be in the chat a little bit more than I normally would be in a lecture because they've arranged this stage in a way that it's unusable for me. And so I will not be using the whiteboard. I'll use the chat instead. Okay, so we've spent the last few weeks of class talking about law, right? Talking about ways in which law governs our relations to property, and talking about ways that law can lead to unjust results or results that we might critique, right? That's been part of what we've been talking about throughout the course of our sessions so far. For the next few weeks, we're going to be discussing equity. And the idea is that equity is to some extent an alternative to law, and also to some extent a supplement, and to some extent a companion. What do I mean by that? I mean that there are going to be times where an equitable determination is going to supplant what law would require. And that's going to be despite some of the things that we're going to talk about this week. But there are times where equity steps in the place of law and replaces the legal outcome with the equitable one. What do I mean by supplement? I mean that there are situations that the law could not cover traditionally. And that in those situations, judges, especially chancery judges in England, would turn to equity and would ask themselves, what is the equitable result? Finally, a companion to law, equity in the modern sense has become a mechanism for providing certain remedies that law does not provide. And that is equity's primary role in the modern day, is remedies. But in order to understand equitable remedies, we have to understand the background and the evolution of equity. So, and equity plays a role in property in particular, in a couple of other areas that we're going to be talking about. So this week, we're going to be starting by talking just sort of very broadly about what equity is, how it works, what it means, etc. Next week, we will be discussing co-ownership and partition. And the reason that we're structuring the class this way is that there's a lot of equitable issues related to how we manage co-ownership of property and how we manage partitioning property among owners that have fallen out, okay? So we have to start by understanding the basics of equity, then we talk about co-ownership and partition, then we're going to talk about the rules of priorities and the rules of licenses that are specific types of equitable interests and equitable rules. And then finally, we're going to close our discussion of equity sort of standing alone by talking about adverse possession, which is a hybrid doctrine. I've heard it described both as a doctrine of law and as a doctrine of equity that is a mechanism for how, among other things, squatters can acquire rights to property. I know that several of you are interested in squatters' rights. Adverse possession is one mechanism through which how we operate to provide squatters' rights. So with that, off to the races. Okay. So what is the difference between law and equity? And this is not a question for you guys. This is a rhetorical question that I am going to answer for you. Okay. So the difference between law and equity comes out of the shortcomings of formalism. Okay. So we go back to medieval England, right? Post 1066, the development of Anglo-Norman law and the development of the system of writs in the law courts, right? So in torts, you learned about the writ of trespass. In contracts, you learned about the writ of assumpsit, right? And the whole basis of the law courts was that you had to plead the right writ in order to receive relief, right? And so if you came into court and you had a breach of contract, right? You had a contractual agreement that one party had failed to perform, but you pleaded your case as a writ of trespass, your case would be dismissed and you would be sent on your way with nothing. Okay? Even if you were correct as to the facts and the law, by pleading wrongly, you were done. And you only got one bite at the apple in the law courts for any given dispute. Okay? So the courts of chancery developed under the supervision of the Lord Chancellor and eventually his clerks and other judges that were intended to provide what was sometimes referred to as the conscience of the king. The conscience of the king. The idea being that the king, and through him, the crown and the realm, were not prepared to accept unjust results. And so you could refer to the courts of equity, to the courts of chancery, to avoid an unjust result that the law courts would be required to provide. Okay? This is the origin of the divide between law and equity. There were problems with this system, right? There are limits to both systems. We just talked about how the growth of equity develops because of a limit in the law, right? The inability to provide just results under certain facts. Okay. Another limitation in law is the limitation on remedies. Okay. The law courts historically provided one type of remedy for most cases. There are exceptions, but for most cases, the remedy that you got for a dispute in the law courts was money damages. Now, the major exception is you could bring a writ of habeas corpus and the courts would order the release of a prisoner. But, writs of trespass, writs of assumpsit, writs of prohibition, the usual remedy for common law writs was an award of money damages. But there are times when money damages are insufficient. And so equitable remedies, which is the major mechanism through which equity still operates, were mechanisms that were initially mechanisms to provide remedies that law could not, but that would be just to provide. But there were limits to how far equity could go. Okay. Right? The major limit is that equity operates against persons. Equity operates against persons. So you remember how early in the semester we talked about the difference between in rem rights and in personam rights? Yes? No? Looking for the north-south nod. Okay, not the east-west nod. Yeah, right. So we remember this, and we remember, right? We talked about how Professor Owusu characterizes in rem rights as being rights against the whole world, and Professor Render characterizes them as rights that attach to objects. And we talked about how those aren't really that hard to reconcile, right? They're not inconsistent with one another. And equity says, screw all of this, we want nothing to do with it. Okay? Equity says, we only operate against the person that is in front of us, which means that equitable rights only operate in personam. What does that mean? It means that if your interest in anything, right, be it a piece of land, be it a contractual agreement, be it a general interest out in the world, if it is characterized as equitable, it is only enforceable against people who know about it. Because it would be unjust to enforce a right against someone who had no clue that it could be enforced against them, right? And because it's not an in rem right, because it doesn't attach to the object itself, you can't enforce it against the entire world. So, right? This leads to some consequences, right? This becomes really important when we start thinking about the estates created by the Law of Property Act, right? How the Law of Property Act 1925 says that there's two types of legal estates in land: fee simple absolute and term of years absolute, right? We remember this? North-south nod, east-west nod, okay? What that means is that every other estate or interest is equitable, which means that it only applies if someone knows about it. Now, in modern times, in modern systems of property, this is not that big a deal, because for the most part, modern systems of property have implemented registration systems where estates and interests in land and conveyances are registered with the state. And they can be registered using a deed registry mechanism or a Torrens title registration system. And to be perfectly frank, I know that there's a difference between the two. And if you ask me what the difference is, I'm going to tell you, let's talk about it in about 3 or 4 weeks when we get to that part of the course. Because I don't know the difference yet. I'm going to let you guys in on a little secret about how the sausage is made. Most of the time when professors are teaching a new prep, we're staying about a week and a half ahead of you guys. If we haven't taught the class before, there's a very good chance that if it's more than about a week and a half or 2 weeks ahead of where we are today in the class, that we don't know it. I can tell you that in my case, it is always going to be true. So something that's new to me, I'm learning it just a little bit ahead of you guys. Which means that part of my job is to make sure that I understand it well enough to help you guys understand it. Okay. So to come back to equity, right? The idea behind these registration systems is that they are intended to put people on notice, because under equity, you are presumed, or sometimes required, is how it's phrased, to undertake a reasonable and prudent inquiry. Okay? So let me put a couple of things in the chat just to sort of sum up a couple of points to make sure that those of you who are not looking at the lecture notes, but are sort of more text-oriented learners, that you have the key phrases here, right? So the difference between law and equity lies with how enforceable your rights are. Legal rights are more enforceable than equitable rights, and the remedies available, where equitable rights have a greater range of available remedies. We're going to talk about those remedies probably, I hope, on Thursday, but that's the plan. The one person who you cannot enforce your equitable rights against with regard in modern systems is what is referred to sometimes as equity's darling or the chancellor's darling, right? But what it refers to is a bona fide purchaser for value without notice. Bona fide purchaser for value without notice. So let's break that down a little bit. What do we mean when we refer to a bona fide? If you are Roman, you would refer to it as a bona fide. But since the Romans are now Italians, we can say bona fide. So what is a bona fide? Yeah. Who has seen, you can raise your hands. Who has seen Oh Brother, Where Art Thou? Lo these many years ago. Anybody seen it? No? Sorry. I grew up in the part of the world that it takes place in, so anyway, there's a point where Ulysses, our protagonist, is talking to his daughters who tell him that their mother's suitors have bona fides, right? Which means that they're real, they're legitimate, they're not frauds, okay? And so this is what we mean when we refer to bona fide in this circumstance, that the transaction where the bona fide purchaser takes is a real transaction. It is not a sham transaction. Okay. What would a sham transaction look like? What do you think might be a sham transaction? Marlon, I think you're right? A sham transaction is fraudulent, but can you, okay, Maisha says that a falsified deed would be a sham transaction. I mean, these are all, right? We all know we've all seen the old timey stories and cartoons of having to prove that a deed is false, right? In modern times, those things don't happen very much because of the registration systems that we use. But one example of a modern sham transaction would be a transaction between one corporation and its own subsidiary, right? The subsidiary does not have the power to refuse to buy or sell, to buy from or to sell to its parent corporation, okay? And so is that a bona fide transaction? Probably not. Probably a sham transaction, okay? What does it mean to be a purchaser? So you have to be bona fide. So the transaction has to be real. It has to be, there probably has to be an arm's length analysis, right? So we have to determine that the buyer and the purchaser aren't involved in any sort of undue relationship. But what does it mean to be a purchaser? What does it mean to be a purchaser? This is another one of those questions where when I tell you, you're gonna, can't believe I didn't think of that. It's one of those things that's obvious when you hear it, but until you hear it, it's not obvious. You got to buy it. Can't be a gift. So you can't give it to somebody and then they're a bona fide purchaser because they didn't buy it. Now you may recall, right? Yeah, Maisha's right. It's the person buying it, right? You may recall from your contracts class, assuming that your contracts teacher told you the same thing that mine did, which I am not assuming, but assuming that they did, we don't inquire into the sufficiency of consideration in a contract, except when we do. Which is a really unhelpful thing to say, but that's what my contracts professor always said. We don't inquire into the sufficiency of consideration, which means in the property context that when you see in the deed for $1 cash in hand plus other good and valuable consideration, you have a purchaser. Because we go, sure, good enough, right? There's a buy, there's consideration. We're not going to inquire any further. Okay? Purchaser for value just means you got to list that $1, right? You can't say, oh, he bought it for those of you who were not in the room. Yeah, that was on purpose. So Maisha says what? And that's exactly the right reaction. So, so yeah, you have to buy the land and you have to be able to tell us what you paid for it, because there has to be value exchanged. And finally, the without notice part. Okay. In modern times, that means a lot more than it used to. Yeah, go ahead. What? Oh, sorry. Perry, did you come off mute? Did you have something? No? Okay. Okay. So without notice means a lot more than it used to, because the requirement is still the same, but because of modern registration systems, to the extent that they've been implemented, and they are not fully implemented everywhere in the Caribbean, but to the extent that they're implemented, modern registration systems basically put every potential buyer on notice. Okay. The intention of and the purpose of modern registration systems is to provide a complete chain of title that lists all current interests in the land. Okay. So that no person can claim to have taken without notice. So in order to be a bona fide purchaser for value without notice, nowadays, you basically have to do a few things, and I'm going to put them in the chat so that you can see. So you have to be a bona fide purchaser for value, right? And we've gone through what all of that means. So you got to be a bona fide purchaser for value. You have to check and confirm the title registry system and that there's no impediments to title right. You have to get a clean title issued. Probably you're going to have to buy some form of title insurance. And we're going to talk about title. Well, at one point, I thought we were going to talk about title insurance when we talked about registration systems, but now I can't remember if I took those readings off the syllabus or not. Anyway, title insurance is just like any other insurance. It pays out if you jump through the hoops of making sure there was clean title and you thought there was and there wasn't. And on top of all of that, there has to be some sort of equitable interest that you missed in the chain of title. Usually it's going to have to be an interest that is not in the registration system. Okay. I'm sorry?
I didn't get the relevance of the last part. So I don't understand after you said the criteria. I don't understand the significance of these.
Okay, so the idea is that these are the requirements nowadays to be a bona fide purchaser for value without notice, which means that this is what's required in order to be able to avoid someone else's equitable interest. Okay. In a modern registration system, right? Where the registration system is incomplete or not present, you do have to undertake a prudent and diligent inquiry into what the chain of title might be. And to be perfectly frank with you, I don't know what that looks like.
What, the chain of title?
What a prudent and diligent inquiry would look like where there's no title registration system. So that's so Tiani says it's a lot of searching. I think that's probably right, you know. And I mean, even in modern, well, Tiani says it's a lot of searching in the registry. So let me push back on that. That's a modern registration system, right? We're talking about a system where there is no system of deed books. There is no Torin system. It's, you know, I'm talking about like, you know, you have to go and find the lost will of the prior owner to prove who inherits the property, right? That's what I'm talking about. So the paper deed books, right? The paper registry is a modern system where, you know, you know, you can go, you start with book 75, plat, you know, page 12, and then you go to that page and it tells you that the owner who's selling the piece of property acquired the property via deed that's recorded in book 48, page 376, right? And then the next, you go to that page, right? Page 376 of book 48, and it tells you that the seller acquired it through a deed that's recorded in book 12, page 1342.
That's in the formal registry.
Right, right. This is the registry system. Okay. So when I say modern, right, don't think that I mean electronic. I mean post-medieval. So electronic systems, I agree, are much easier. So where the modern system has been updated to be postmodern, for the literature fans among us, then yes, that's much simpler. Boy, and yeah, Tiffany's right that going through the deed books is still a lot of work, but it's so much simpler than trying to figure it out before the registration system. Now, Maisha asks, if the registry doesn't exist, would you have to place some notice in the papers or things of that sort? And the answer is, I don't know. I honestly don't know. I've never operated without a registration system. And it's still a ton of work to make sure that clear title exists. So,
well, sir, with Manisha's question, I think at some point, even if you have a title, you have to put it in a need to do. So
yeah, that would make sense to me that there's some sort of publication requirement to, you know, engage to as part of the diligent inquiry to, you know, sort of put out there in the world, hey, I'm trying to figure out who owns this piece of property. And if you think you do, you need to come and talk to me, right? And that strikes me as not unreasonable given sort of what we use publication for in law, right? So I think that's probably right. That at some point there would be some sort of notice in the paper related to this. But I mean, this becomes a massive undertaking that requires a lot of time and a lot of effort and a lot of money, right? And so registration systems are mechanisms to democratize property transfers, right? To make it so that it's easier and simpler and does not require the same type of resources to acquire and dispose of land. Okay. Okay. So, do we feel comfortable understanding the concept of where of what a bona fide purchaser without notice is and why they matter? Okay, hearing yes in the room, in the chat, yes, no. Okay, not sure why they matter. Great, okay. So the bona fide purchaser without notice matters. They matter because equity will not enforce its interests against one. Okay? So if you are a bona fide purchaser without notice, and we've established that in the year 2020, that's actually very difficult. But if you are one, then any equitable interests that might exist don't apply to you. And so this includes defeasible fees. It includes future interests. It includes easements, right? It includes licenses. Okay, so the only thing it doesn't include is the fee simple absolute and the term of years absolute. Now, there are jurisdictions that have more legal estates and legal interests than just that.
Look, sir.
Yes.
The bona fide purchase of basically proceeds inclusive interest, except here there's a fee simple absolute and
a term of years absolute, basically a lease. They don't supersede equitable interests except for those two. Those two are not equitable interests.
Okay. So, but that's because of the LPA 1925.
Right.
So what about like it's maybe that's well, what's about common law countries that we recognize LPA or all common law countries?
Boy, that gets into issues of reception. Nicole, I've seen your question. I'm not ignoring you. And, you know, when law is received is a tricky thing. My presumption, and I know that there are circumstances where this is incorrect, but I can't tell you off the top of my head what they are. But my presumption is that unless I know otherwise, I expect that the reception date is the same as independence.
So all common law countries go by this.
All common law countries that I know of have a reception mechanism. So they have a point beyond which they no longer apply English law. Okay. There's a lot of places in the Caribbean that assert that their reception date is sometime in the 19th century. Barbados being one of them. I'm not entirely sure how that works because then what law governed between the reception date and independence? Does that make sense?
Yeah.
Like, I understand that that's the assertion that the courts make, and I respect that. I can't get it to work in my head. So
I think my actual question is, no matter where I go in the Caribbean, right? It's always going to be visiting absolutes and terms of years absolute that are the only interests that Equitable are not enforcing finance. So if I practice in Jamaica, it's going to be the same there. It's going to be the same in Barbados. The actions.
boy, I want to tell you yes. I really want to tell you yes. But what I'm going to do is I'm going to look it up and double check and make sure and give you a hard answer on Thursday. Okay?
I see something in the course, in the so I think it's talking about, I think it was talking about some exceptions with St. Lucia.
Yeah, in general, anything that we talk about in this class, things are going to be a little bit different in St. Lucia and Guyana. They may be very different. They may just be a little bit different, but you should not expect that anything that we discuss will apply in either of those two places. Unless we're specifically discussing them, right? So, okay. Now do we feel a little more comfortable about the BFP? Cole, can you explain your question a little bit more? I'm sorry.
Hi, sir. Yeah, no, what I was wondering in terms of understanding the BFP is whether
Hang on. My computer didn't switch the speaker and I missed that. So let me, okay. Go ahead. I'm
Yeah,
sorry.
I'm trying to understand the BFP when you were saying that it matters because equity will not enforce against a BFP without BFP. And I'm asking whether the difference is what's covered under the law and what's covered under equity, if it's filling the gap.
I mean, that is certainly one way to conceptualize how we think about equity in general, is that it's filling gaps in the law. And that actually, I think that leads very nicely to the rest of what I wanted to cover today. The vast majority of equity comes from what was sometimes referred to as the maxims of equity. Okay, and on the lecture notes, there's a whole list of them. I have put in bold the ones that I think are helpful for you in this class. They are all, none of them are unhelpful, but the ones that are in bold I think are a little more helpful. And specifically the one that I think applies to what you're talking about, Nicole, is that equity follows the law, which means that where there is an adequate remedy at law, if you ever take a class on remedies, when you talk about injunctions, you will talk a lot about adequate remedy at law. Equity takes no action. And so if the legal interest suffices to resolve the dispute in a fair way, equity doesn't care. So in that sense, I think you're right that equity assumes that you're covered by law. Equity only steps in where law falls short. Okay. All right. Couple of these maxims that I want to touch on just in a little bit of detail, right? We talked about how equity acts in personam, how it acts on persons rather than objects. One of them is one who seeks equity must do equity. And similar to that is he who comes into equity must come with clean hands. And basically that means that you can't ask the court to do justice when you have yourself have behaved unjustly. Okay, so one who seeks equity must do equity means that if you want an equitable remedy, you have to be prepared to provide your side of the equities. So for example, one equitable remedy, and we'll talk more about remedies on Thursday, one equitable remedy is specific performance, where instead of getting paid money, you demand the actual thing that you are entitled to. You say, "No, money won't replace this, I want the thing." Okay. Well, in order to get specific performance, you usually have to be willing to pay what you agreed to pay, whatever that is, be it money, be it time, be it, a vintage baseball card. Maybe baseball cards aren't a thing in the Caribbean. But that's what it means for one who seeks equity must do equity. And similarly, he who comes into equity must come with clean hands. So if you ask for an equitable remedy, the defendant has to be able to say, "Well, Your Honor, or my Lord," if we're in England, then he hasn't done anything wrong, and so yeah, he's entitled to it. If you've done something wrong, you're not going to receive an equitable remedy. The last maxim that I want to point out to you is that equity abhors a forfeiture. And this will become more relevant when you talk about mortgages, which I believe is in property 2. But basically, the whole idea behind mortgages and behind deeds of trust and behind foreclosures is to prevent equitable actions to redeem delinquent debt. Okay? All right, so this has been a lot. It's sort of gone in a number of different directions. Let me boil this down to the sort of bare minimum, what you have to take away from today, okay? Equity is different from law. It provides more expansive remedies against fewer people, okay? And equity is intended to provide substantial justice where the common law would fall short. Okay? So on Thursday, we're going to talk a little bit more about the types of things that we did that in equity to acquire equitable interests. And then we're going to talk about equitable remedies. And then next week, we will talk about co-ownership and how that plays into equitable interests. Last thing, and then I'll let you go. Just a reminder for those of you who had tutorials Monday, and I will mention this again for those of you who have tutorials tomorrow and Thursday, to please fill out the midterm evaluation. It's anonymous, so you can tell me exactly what you really think. And because I want to do more of the things that are working and less of the things that aren't. Okay, and a lot of you, some of you have done it already, and I appreciate it. And I certainly will be looking forward to hearing from more of you. So it's on e-learning. It's in the block for this week. All right, so I will see some of you tomorrow and the rest of you on Thursday. So take care and bye.